case. This is State of Ohio plaintiff versus Jacob Wagner. It's case number 2018 CR 154. Today is September 21, 2020. And this matter is scheduled for hearing on motions today, defense motions today. Again, it's September 21, 2020. Appearing today is the defendant. The record will reflect that the defendant is appearing in civilian clothing and without visible restraints. He is represented by his attorneys left to right there is William J. Mooney, Gregory W. Myers, and also John Cornelli is present. All are from the Public Defender's Office, and Mr. Mooney and Mr. Myers are court-appointed counsel to represent the defendant. Present also is the representing the State of Ohio Prosecuting Attorney Ralph Jones, Special Prosecuting Attorney Angela Wagner, Special Prosecuting Attorney David Andrew Wilson, and also Special Agent Brian Scheiderer with Ohio Bureau of Criminal Identification and Investigation. Also present, the defendant has filed motions, and pending right now are motions number 47, 48, 49, 50, 51, and 52. For the sake of the record here, let me say something about those, at least announce what they're titled. 47 is defendant's motion in limine, requesting a pre-trial evidentiary hearing to determine the admissibility of ballistic evidence and opinions. 48 is defendant's motion in limine, requesting a pre-trial hearing to determine the admissibility of shoe print evidence and opinions. 49 is defendant's motion in limine, requesting a pre-trial hearing to determine the admissibility of any written communications the state intends to present in its case in chief. 50 is defendant's motion in limine, requesting a pre-trial evidentiary hearing to determine the admissibility of any non-testifying co-defendant statements the state intends to present in its case in chief. 51 is defendant's motion and it's called notice of an actual conflict and motion to revoke Andrew Wilson's appointment as special prosecuting attorney. 52 is defendant's motion for an order requiring the prosecution to provide a transcript of audio recordings it intends to introduce at trial. And finally, 53 is defendant's motion for an order compelling the state of Ohio to provide defendant with all forensic expert reports and underlying data. It's the court's understanding that the defense, Mr. Moody or Mr. Myers, does not wish to proceed today on motions 47 and 48, but has requested that those be rescheduled and that the counsel for each side has agreed on October 29 at 1 o'clock p.m. for hearing on motions 47 and 48. Is that correct?
Yes, Your Honor.
Also, October 29 at 1 o'clock p.m. will be the extended date for the state of Ohio, and this is on agreement of the parties, for the state of Ohio to furnish the defense with specific information concerning any criminal rule 404B material, other acts type material that the state intends to use at trial.
And if I may, Judge, just for the record, that relates back to our number 23.
That's motion 23.
Right, and we understand and agree that the extended deadline is now October 29.
And that's agreed by?
Yes.
Is that correct?
Yes, I'm sorry, yes.
The state agrees on that day too?
Yes, Your Honor. Thank you.
Motions number 52 and 53, it's the court's understanding that the state of Ohio has agreed to provide the defense with the material requested in 52 and 53. Is that correct?
Yes, Your Honor, we did not speak about dates, but this was also addressed in George Wagner's hearing. And at that time, as far as 52, which I believe is the transcription stuff, that was, we agreed to the date just by the end of the year, December 31st of 2020, which we did not discuss back in chambers. And we will certainly provide the requested data from the expert as soon as we get our hands on the same. So this is additional requests beyond what they've already been provided regarding the experts.
Right.
So 52 states agreeing to furnish the transcripts of the audio recordings the state intends to introduce at trial by December 31 of this year, correct? And that's agreed to by the
Yes.
judge. And then concerning the forensic expert reports and underlying data, some of those have already been furnished, is that right?
Yes, Your Honor. The majority of stuff has been provided to them. We provided them all the bench notes for all of our expert reports from the Bureau of Criminal Investigations. However, in the most recent discovery dump, we gave them 2 new reports that we did not give them bench notes for, but they're now requesting those. And then we did not have bench notes for Dr. Bodziak, so we will attempt to get those as soon as possible. If we want to make the October 29th the deadline for that,
If
too.
that's at all possible, I was just going to
Sure,
say, certainly the Bodziak relates directly to our motion 48, which is shoe print. We've seen, as Ms. Canepa mentioned, the concluding report, but again, it's the underlying data we're looking for. And Ms. Canepa, if I can, clarification, the 2 most recent forensic reports, those are ballistics, is that right?
That is correct, Your Honor.
And those are BCI ballistics, so that
Correct.
underlying bench note data is going to be pretty easily available.
Probably, yes.
All right.
So that would be by October 29,
Sure.
number 53, and defense agrees on that date.
Yes.
So we have the 49 and 50 dealt with the state's motion in 49 to determine the admissibility of written communications and that the state intends to use, and 50 to a hearing to determine the admissibility of any non-testifying co-defendant statements that the state intends to use. I'm not sure whether this is agreed to or not. Of course, the state has argued that they feel the defense should put together specific objections to whatever portions of those communications and or statements that the defense is objecting to. Now, along with that is the fact that the court's understanding from we need to put this on the record, but in our discussions in chambers, that the state has now prepared to certify that the defense has all discoverable material. The state has furnished the defense.
That is correct, Your Honor. Everything that we have, we've certified that it has been provided to opposing counsel. And I'm not going to remember the date, but it's been provided to them.
And so the defense with that is going to be preparing, I don't know if it will be an indemnity to those motions or amended motions, but to specifically object to whatever communications and or statements of non-testifying co-defendants of the state.
Yes, Your Honor. It's our understanding, pursuant to Chamber's conversation to prepare for this on-record hearing, that the court indicated that the defense should come forward with I think we'll probably caption a supplemental memo in support that will endeavor to do our best to identify in anticipation the specific statements and documents that we would like to place an issue for in limine review.
All right, and we can have a hearing. Is it anticipated we'll be arguing those on the 29th at 1 o'clock as well, October 29th? Or is that too soon?
Well, I don't know if that's too soon or not. It might be. I I mean, I think both sides, as the motions are laid out, the defense initial 4950, the state's replies filed June 22nd, lay out the law. I suppose the question becomes, when we're going to be debating the facts, can we agree as counsel for the parties to, if the court is going to consider the in limine issues presented as discussed in chambers, confrontation, hearsay, and all that, then can we adequately present, by way of agreement, the facts at issue, or is it going to actually entail an evidentiary hearing? I suspect we can agree, but whether we get that done on time, because the other thing that happened in chambers, just to recount it, defense was taking the position that it would seem to us, for example, that, just as an example, statements attributed to Angela Wagner regarding a certain set of shoes seemed to be fundamentally admissible if and only if the court ruled in the state's favor as statements of co-conspirators. And Counsel Wilson mentioned that may not be the only way. That statements, and perhaps others like it, may have a pathway to admissibility for the prosecution. Long-winded way of saying is there may be more fighting and writing to be done as we progress on these particulars.
So something we would at least look at on October 29 at the hearing on that day. With respect to defendant's motion 51, which was concerning alleged actual conflict concerning the appointment of Andrew Wilson, and the court will reserve ruling on that and might issue a ruling on it before October 29. The defense, I believe, felt that there may be a reply to the responsive memorandum filed with the state today. Is that correct?
That is correct, Judge, and we will endeavor to get that done by the end of this month. I don't think it'll be an elaborate reply. It's just a few of the arguments the state propounded in their reply that or their response that we received today. I would also like to add, as we move forward now on motion 51, I would suggest we put our agreed facts or stipulation into this record now, so that to the extent the court is contemplating these issues, there wouldn't be any dispute as to the facts that underlie the legal argument. Fair? Do that?
Yes.
So on defendant's behalf, Your Honor, in discussion with counsel for the state, as well as in chambers with this court, it's defense understanding that the state stands ready to agree that the facts uttered in defendant's motion number 51 are an accurate statement of the interplay between the Ohio Public Defender's Office and the Ohio Governor's Office. Concerning Mr. Wilson's employment by the Governor's
Correct.
Office and the relationship between the Governor and the Public Defender's Office.
Right.
So forth. Facts is set forth there. As the state is stipulating that those facts are accurate.
Yes, Your Honor, we are stipulating that the underlying facts are true. Obviously dispute that that amounts to a conflict.
And I believe, finally, I think that, I'm not sure it's final, but I think it's finally the last thing. I think the defense was going to request a transcript of the hearing.
Yes, thank you for reminding me of that, Judge. We would like to make an oral motion that the court issue an order to the court reporter permitting her at state expense to provide us with a transcript of the bond hearing held for co-defendant George Wagner.
And state's position on that.
Wouldn't have any objection to that. We would like one too, though, Your Honor.
Court will report a copy of that transcript.
I think that's all.
Provided to the defense and to the state. One thing, that transcript is to include exhibits. Those exhibits were being held under seal. So the order would also caution counsel that that's for counsel only, the exhibits that went with.
Well, yes, if I may, I think I can speak for defense team. All we need is the transcript. We are privy to the audio visual through a media television recording. And yes, to the extent that there were references to exhibits, those are exhibits that we already have pursuant to discovery disclosures.
The court will order the transcript be prepared by the reporter and copy provided to the defense and the state attorneys. Anything further that we need to put on this record today?
Nothing from the defense.
Not on behalf of the state, Your Honor.
No, thank you very much. We are adjourned.
Thank you.
Thank you, Your Honor.
The girl with the long hair has been giving us pretty hard heat stairs. Yeah. The woman here that stared us down. Don't worry about it.